Welcome to the rvatech Data Summit series. This is our second month. Today we're going to be talking about data privacy. My name is Lori Jennings. I am the founder of Jennings ProSearch, an IT and data executive search firm, and I'm also the 2021 Data Summit chair. All right, again, this is our second event. We're going to be doing something every single month, so be sure to check out the rvatech website to see what the upcoming events are. On May 18th, we are going to be doing 3 interactive workshops. They'll be 3 hours in duration, and we'll have one, an intro to machine learning, as well as natural language processing and introduction to neural networks. So you don't want to miss that. Thank you. All right, before we get started, let's thank our sponsors. We really appreciate them. Here they are. Thank you to Altria, CarMax, Creative, Impact Makers, Solvaria, Vaco, University of Virginia, and Wipro. Thank you. And also want to thank our committee who meets on a weekly basis to make these events happen. Thank you. And thank you to CapTech this month and Eric and his team for helping put this together. All right. Well, let's get going. To start off today, I want to introduce Chris Jones, attorney at Sands Anderson. He's going to give us an overview of the data privacy law before we get into the panel discussion. A little bit about Chris. Again, he's an attorney at Sands Anderson and is Ccpa US certified. He's been litigating in state and federal courts for 14 years and then became a founding member of the cybersecurity and technology team when he moved over to Sands Anderson 5 years ago. There he works with clients on litigation, breaches, and data privacy issues. Thank you and welcome, Chris.
Just unmute myself there. Thanks, Lori. I'm going to try to keep this brief because I know the other panelists have a lot to talk about, but as Lori said, we all thought it'd be helpful to take a few minutes to talk about the basic requirements of the VCDPA, which I'm going to refer to as the Act, so I'm not tripping over my tongue for the next 5 minutes. When I look at legislation, I tend to look at it as something that begins by providing a grant, a large general grant, and then it kind of ratchets back that general grant of new powers or rights. And in doing so, it strives to create a certain type of balance. And that's what we have here with the Act, and I think that we have a fairly balanced piece of legislation. But we start with the application of the Act, which is fairly broad. It applies to businesses that control or process the data of 100,000 or more Virginians, or 25,000 if the organization derives 50% or more of its revenue from the sale of data. The definition of personal data is extremely broad. It's data that is linked to or linkable to an identifiable natural person. The definition of process is also very broad and includes simply storing that data. So then after this broad grant, we have our rollback. There's a whole host of exemptions. For instance, all Commonwealth agencies are exempted from the Act. And data types and industries that are already heavily regulated are also exempted, mostly in the health and finance area. I do expect that as we move forward, and bear in mind, the Act doesn't actually go into law until 2023. But I think down the road from there, I think we'll see the broad application of this Act get even broader as businesses get used to the requirements, and more importantly, as consumers get used to the type of rights that are being safeguarded by the Act and come to demand those Act from more businesses. I expect we'll see that 100,000 threshold lowered somewhat. So the question is, what does the consumer, what rights does the Act actually confer? Why do consumers benefit? Well, they have a number of new substantive rights that did not exist before the Act. They can request that any organization that is controlling or processing their data provide them access to that data, provide them with a copy of that data, correct any inaccuracies in that data, and also delete that data. They're also allowed to opt out of certain functions like targeted advertising or the sale of information or certain customer profiling. And here's where our balance comes in again, and this is a big one. The controller or the processor, they're not required to comply with the consumer request. Basically, if it would be too hard to do that, or if it's not necessary to do that. And by too hard, what I mean is if the organization would have to spend an unreasonable amount of time, money, resources trying to associate the request with the data requested, that it just becomes an unreasonably consuming request. Or as far as necessity, if the data is maintained synonymously, then the risk to the consumer of any bad thing happening because of that data is significantly reduced. And so the Act provides for that. The Act also, of course, it has a number of obligations, new obligations that these organizations must adhere to in addition to responding to these consumer requests. I think the biggest of these, and it's not biggest in terms of ink spilled in the Act, but it's biggest in terms of impact, is the requirement that these organizations that qualify under the Act, to which the Act applies, that they establish, implement, and maintain reasonable administrative, technical, and procedural data security practices to protect the confidentiality, integrity, and availability of the data. So again, this occupies only 3 lines in the Act, but the impact is huge. This means essentially that organizations meeting the threshold of the Act, they're now required to have full data security programs with data privacy and cybersecurity elements, but they haven't been told yet what these requirements are going to be. The regulators have to still fill in the details of this. We don't know what the reasonable practices are that organizations have to meet, and we can only hope that the regulators strike again a good balance in terms of consumer rights versus burden on businesses. I think a good place to look if you want to try and predict where this is going to go is to the Virginia Insurance Data Security Act. That is, as it sounds, a piece of legislation that applies only to the insurance industry in Virginia. It's a little bit older than the Act. It's already law, and it's already going through the regulation process. And the regulators, I think, are in their 2nd round on that, and they are answering the very question of how do we flush out the requirements of this security program. So this is a good place to look to see if we want to see where things are headed. There's a number of other requirements under the Act that I won't get too heavily into right now. A lot of them are not or should not be very controversial. Things that are already a part of good security programs in companies throughout the country. Things like providing clear privacy notices, unambiguous, easy to find, advising your consumers about what exactly they're getting into, limiting collection of personal data only to what's required, and processing the data only when and how is required. One issue that I've kind of had catch my attention and it's probably because I'm a litigator, so I'll just touch on it briefly. But that's the requirement that certain organizations, when processing certain types of data, that they actually produce protection assessments. That's basically an assessment of whether all the things that they're doing to protect this data are effective. And these assessments have to be made available to the Attorney General's office on request. And the reason that gets my attention is that you basically have a law that's now requiring businesses to produce a document that sort of lays out all the warts, potentially, of their own programs. And that's the sort of thing that any plaintiff's attorney would be really happy to come across in discovery. So again, the Act strikes some balance. It does exempt these documents from FOIA. They're not publicly available under FOIA. And there's also some good sounding language about how this law is not construed to waive any evidentiary privileges. But that doesn't address the question of whether those privileges would apply in the first place. So that's certainly something I'm keeping an eye on. As far as enforcement goes, it's the Attorney General's office that's charged with enforcement. There's a new office being created within the Attorney General Department. We expect about 3 employees or so to be charged initially with enforcing the Act. There is no private right of action under the Act, even for breaches. And I think another area where the Act has struck a pretty good balance is that there's potentially hefty fines for violations, $7,500. That may not sound like much, but again, we're talking about per violation. So when you start thinking about how that can be multiplied out by number of violations per consumer, and then multiplied by the number of consumers, we can start getting into pretty large numbers. So again, that'll get everyone's attention, but then the balancing element is the safe harbor. The Act requires that the Attorney General first notify any organization of a potential violation And then that organization has 30 days in which to cure it. If it does, there'll be no adverse action. Finally, I just want to touch on some comparisons between the Act and some of its more famous forebears, the CCPA and the GDPR. The CCPA has an absolute revenue threshold of $25 million. That means it's going to apply to any organization that is deriving revenue of more than $25 million. Virginia does not have that. Virginia has the 100,000 consumer threshold. California also has a consumer threshold, but its consumer threshold also includes consumers who are acting in a business context, whereas in Virginia, it's limited only to individuals and households. In terms of substantive rights, the Act does provide the right to correct errors in data, as does the GDPR. CCPA does not, but there's some follow-up legislation, CPRA, which is addressing that. And then in terms of enforcement, GDPR has famously massive fines. The fines, as we've looked at under the Act, are a bit more modest. And we've also seen the Act has no private right of action. The CCPA does have a private right of action for data breaches. And that's something that's caused a little bit of controversy. Some people think that the Act hasn't quite gotten the balance right there. As a defense attorney, I think it's a good place to be. I like the fact that we have the Attorney General's office, at least initially, being the enforcer of this. I think that will lead to a cleaner process. And with that, I'll turn that over back to Lori, but I'll be sticking around, listening to the other presenters, and available to answer any questions anyone might have.
Thank you, Chris. All right, so let me introduce the moderator for our panel, Janine Cook, manager at Captech Consulting. She has over 12 years of diverse technical program and project management experience that often focuses on the intersection of business and technology. She managed a Fortune 200 company's response to CCPA, and she also co-leads Captech's privacy service offering and serves as an internal consultant for other privacy opportunities. Welcome, Janine, and thank you for being here.
Thanks, Lori. Hi, everyone, and thanks for joining us today. I did want to throw just a quick reminder in that if you have any questions, to send them along in the chat. And then we'll be seeing any remaining time or even stay on a little after the allotted time to go over questions we receive from you. And I believe we actually will have Chris available to us for the Q&A. So please include any questions you have for him. All right, before we get started, I'd like to have the panelists introduce themselves. And John, why don't you kick us off?
Thanks very much, Janine. My name is John Duncan. I work for CarMax. I've been with the company for 4 years and manage our data governance function for the company, as well as the data product management function in supporting our master data and other data assets. Prior to CarMax, I was with Capital One for 16 years. By way of interest, I've got 2 boys at VMI. One's going to get married here shortly, right after he graduates. So a lot going on this summer, but thanks very much for having me today.
Great. Let's see, Kyle, you want to go ahead?
Sure. So thanks for having me. Happy spring to everybody. For those that suffer from allergies, I think we've almost made it. So congratulations. My name's Kyle Fonder, and I lead the consumer identity management team at Altria. We're focused on age and identity verification, fraud mitigation, and also privacy operations. My team's housed within the digital and technology organization, so we really work as a bridge between marketing and technology. And in addition to managing privacy operations, my team also is responsible for implementing any new privacy requirements. So again, thanks for having me. Looking forward to the conversation.
Great. Last but not least, Caroline.
Sure. Hey, everyone. I'm Caroline Stapleton. I'm the Assistant General Counsel and Head of Compliance at West Creek Financial. We're a consumer finance company. We partner with retailers around the country to bring consumers lease-to-own and loan products so they can buy the things that they need. And as part of that, and Head of Compliance, I and my team are responsible for making sure that we understand and implement all of the privacy obligations under the state laws where we operate. It's been definitely a challenge for all companies who are affected by these new statutes over the past couple of years. And I think we don't really see an end in sight. Expect that more states will be enacting their own versions. I think that's part of why conversations like this are so exciting. We're trying to not only talk about what we know, but read the tea leaves for where things are going. So, and before this, I was at a law firm, Buckley, out of Washington, D.C., and we advise their consumer finance companies and other bank and non-bank financial institutions on things like privacy compliance.
Great. Thanks, Caroline. Okay, so now that we know a little bit more about everybody's background, let's jump into the discussion. Okay. John and Kyle, as you think about how your organization prepared for CCPA, what was your biggest challenge? What was the biggest challenge you faced, and how does that play a role, if at all, in how you'll respond to Virginia's privacy law or the Act?
Kyle, I can go first. It's up to you.
Go ahead, John. You got it.
Thanks. So absolutely in the beginning, particularly for CCPA, it was a challenge to make sure we had the right level of program governance and the communication across the company, from whether it was our C-level leaders all the way down to our developers and testers. Data and privacy is absolutely, both of those are important topics for everybody at the company. But given the breadth of the requirement, just early on, it was like, how do we make sure that we can really stay aligned and coordinate both from across and down through the organization? Luckily for us, our senior team got on board very quickly. They helped us shape the governance model, but they also helped assign the right folks and great leaders to work with our core team charged with the overall CCPA program. And so we had to work really hard to communicate across and down for more than a year to be prepared. But because we had that governance and communication model well established, it was really awesome to see just how folks were all in and aligned in helping make sure we built the right solution for our consumers. We maintain that program structure today, a broader data privacy program. It still guides us in how we think about some of the ongoing CCPA work. And we feel pretty good that will be the ongoing model that we'll lean on as we continue to prepare for the Virginia law. And with that, I turn it over to you, Kyle.
Yeah, so I think the biggest challenge that we face with CCPA, as somebody who leads a team that is operationalizing and leading projects to meet these requirements, with CCPA, it was really understanding what we needed to do. I think CCPA had a lot of commentary in its process, and it was a pretty lengthy process. It went from getting signed in June of 2018, and there was this period where folks that were in this privacy space will remember, where we were all asking ourselves, what are you doing? How far along are you? And what are we supposed to build and when? And we were kind of all sitting around waiting for clarity. And I think with CCPA, that was a bit of a challenge. And it wasn't until October of 2019 that the amendments actually got signed. And at that point, we kind of, I'll say, knew what we needed to do, or at least had a pretty good understanding of the requirements. Even since then, there's been 4 modifications of CCPA, one most recently in March. So when I think about the difficulties of CCPA, a lot of it was just having that patience as we went through that process. I think when it comes to preparing for Virginia, I think a lot of companies will probably have a little bit more patience than we did with CCPA. There's a lot of privacy work that's already been done. So I don't think it's necessarily wrong to go ahead and start thinking about it early in terms of, hey, what do we have today? What's the overlap? What are those brand new requirements? What can we build from? But I don't see companies getting too far ahead, just given the experience we had with CCPA. The last thing that I will mention, rely heavily on your counsel. There's going to be articles, webinars, there may be some panels, and it's all good. It's all great information. It's good to kind of be in the space. But when it comes to really understanding how to execute, a lot of that can get a little bit, it can turn a little bit into noise. So really, really rely heavily on your counsel.
Great, thank you both. Yeah, and Kyle, I think when you talk about all the changes, and John, even when you talked about the organizational shifts you guys had to go through, my expectation is a lot of companies had to go through the same thing, and the work that you guys put in now will really make these subsequent state acts that come out a lot easier to respond to. And Kyle, like you mentioned, if things are still changing or clarification is still coming, it'll be much smaller, changes. Now that there's 2 laws, hopefully some that are to come will be more copycat laws that, will have the same elements that a lot of companies already have the ability to respond to. Okay. So if we compare Virginia's law, like Chris did for us, to California's law, Virginia lawmakers decided not to make some notable changes. And Chris, thanks for going through some of those in a lot more detail than I will. But one of them is adding in the right to edit data, excluding a private right to action. Now, Caroline and John, I'm curious to know if you could change one aspect of the Virginia law, what would you change and why?
I can kick that off. I mean, there are a couple of, first of all, if I could change the entire thing to mirror the Ccpa just to avoid the need to do a red line essentially and find out what do we need to tweak here and what do we need to do differently here, how do we find the lowest common denominator, that would be nice. But to more practically speaking, I think one difference I noted in looking at the Virginia law is that there is no grace period for enforcement once the law becomes effective. And that's different from California. In California, the law was passed and then it went into effect over a year later. And after that effective date, there was a 6-month grace period that companies had to make sure that as they started to receive these consumer requests to exercise their rights under that law, that everything was functioning properly, the right hand is talking to the left, and there was not a fear that the AG's office was watching you during that first 6 months to make sure that all your T's are crossed and I's are dotted so that you would avoid a fine. And then after that 6-month period, everyone was on notice that you've had your warm up and now it's time to make sure you are 100% compliant to avoid a potential action. Now, that grace period wasn't complete immunity because the private right of action, which a couple of people have mentioned already today, did not have a grace period. Consumers could exercise that ability to bring a lawsuit for a data breach even beginning on January 1st, 2020, when the law became effective. But still, just to have that breathing room from the enforcement perspective at the AG level would be great, because the Virginia law, as we've noted, has a long lead time. We have till 2023 to figure everything out, get everything in place, which sounds like a long time. But until you actually are receiving those consumer inquiries, you don't always know exactly how everything is going to go when you press the on button and you start receiving and responding to the request. So if I could change one thing, I would have a grace period in there. I will note, and Chris mentioned this at the beginning, that one good sort of mitigant there for companies to kind of reduce that fear of enforcement right out the gate is that there is a 30-day cure period if the AG finds that there is an error. As long as it's not a repeat error, you get a notice and you have an opportunity to cure before you could be subject to that potentially quite hefty per violation penalty.
Great. Yeah, that's a great point, Caroline. It's not something that I've really keyed in on, and I kind of wonder if many companies took notice of that grace period being excluded from the Virginia's law. John, what about you? What would you change and why?
Yeah, no, I think Caroline spoke to all of it very well. I mean, ideally, there would be a federal data privacy law. I think that would help provide more consistent guidance on what consumers should expect companies to do with their data or not do with their data, and certainly how companies should appropriately respond to honor the consumer privacy rights. We were fortunate in that we implemented Ccpa nationwide, meaning that we accept requests from all states, not just from California. That helped us build what I think is a pretty solid foundation for then how we kind of lean into what is going to be different for Virginia. So we feel pretty well positioned. But if your company didn't have a ton to do for California or for GDPR, I would certainly echo also kind of Caroline's advice just around 23 seems far away, but it's not. There's a lot of work that goes into making sure that your infrastructure and your process is conducive to taking internal teams, pulling that data together, if that's not already kind of an approach that you've built or that you have for other purposes. And certainly the governance component that I mentioned earlier around making sure all the right folks that have both a voice and a vote towards how you're going to make some of those judgment calls around scope and around timing is super important. And so in absence of that at federal law, I do think that we're positioned to meet state-specific requirements, but I couldn't agree more with Caroline to really invest time to compare and contrast the differences between California and Virginia.
Yeah, John, that's definitely a big one. I think, you know, a lot of us maybe on the call, if you're interested in data privacy, which you probably are if you're here, when you're on IAPP's website and you're seeing the map light up, you know, all the different colors of states that are starting to talk about enacting their own privacy laws, to find out if maybe something federal is to come. So it'll be really interesting to see, you know, now that Virginia's has one in place and a couple other states to follow when a federal law will actually happen. And I also think it's really interesting that you guys just responded to Ccpa with the by giving the right to everybody. I have seen a good amount of other companies do that as well. So I thought that was interesting that you called that out. All right, so we've talked about this next topic a little bit already, and it's on the private right to action. So as a few of us have already mentioned, Virginia's law does not include a private right to action. And we've talked about it a little bit, but putting it very plainly, Ccpa allows California consumers to sue companies under certain circumstances. And in Virginia, they don't have that right. It lays on the Attorney General to do that for you. And so Caroline, this one is for you. Do you think that excluding a private right to action will make an impact on how companies will respond to the law or the enforcement of this law?
Without a doubt. And the way that we can know that for sure is how hotly debated this private right of action is, not just in Virginia, which it was a debated point, although that was sort of an abbreviated legislative session compared to how other states are considering their privacy laws. In other states, this has been a huge hang up. I mean, if you look at Washington state, for example, it's on both sides, you have strong opinions about whether consumers should be able to enforce their privacy rights and to what extent they should be able to do so. Backing all the way up to California. So in California, you'll hear, well, there's a private right of action in California, not in Virginia. You know, consumers in California, it's just so much easier for them to enforce their rights. But really, the private right of action in California is not unlimited. It's actually just limited to unauthorized releases of data when you don't have a security system in place for that meets the reasonableness standards under that law. So it's not even an unlimited private right of action in California. In Virginia, there's none. And that is it's interesting. Will it affect how people react? I think initially, yes. It may make companies feel a little bit of breathing room that, okay, we can take direction from the Attorney General's office to understand how they're going to enforce this, and we can all tailor our responses to one set of standards because that's what it's going to be enforced by, not within different courts within the states making different decisions about what this provision means. The Attorney General is going to make a decision about what that provision means, and everybody will tailor their activities to that. However, I would caution anyone thinking that and kind of breathing easy a little bit on the Virginia law to take a look at some of the cases that have come out of California since the Ccpa went into effect. And when you look at those class actions, what you'll see is kind of interesting. At the very beginning, even though the private right of action was effective as of the effective date of the law, the lawsuits coming in California mentioned the Ccpa, but as a standard of conduct to bring a suit alleging different claims under the fair trade practices law there, for example, or a straight up negligence claim. You know, you've been negligent because you didn't meet the standards in the Ccpa. And so even though the private right of action was there, what you saw was consumers using the ideas and the principles in the Ccpa to make claims under other rights of action. And I think that that's a warning shot for companies in Virginia who think that this lack of a private right of action may mean they'll only face the heat from the Attorney General if they get it wrong. A consumer can try to enforce this law by kind of bootstrapping it in through another law, like Virginia's protections against unfair trade practices, for example, or even a negligence claim, and say, hey, this company they did not have data security protocols that were sufficient. And even though I don't have a private right of action here in Virginia under the CDPA, I'm going to say that the CDPA sets the standard. And if this standard is violated, that's negligent. That's an unfair trade practice. So that would be my caution, just looking at the cases coming out of California. But I do think you'll see a different level of response because it's not written into the statute, and those $7,500 per violation penalties, they cannot be enforced by consumers.
Great. Thanks for that insight, Caroline. I have to admit, I have personally been very excited to get a chance to ask a lawyer that question.
I hope I was able to break it down, because I know we have a lot of folks on this call who aren't lawyers, but I think that you don't have to be a lawyer to understand why this matters to how people react. The fear of facing a lawsuit from a consumer in court is a totally different fear because you've lost control over that process. There's not one person making decisions. It's different courts. And one more thing, I know I've talked a bit about this already, but I will say that there were, during the legislative sessions debating the bills that ultimately became the Virginia Act, there was some discussion about a middle ground that I wonder, if we might have seen that. It's just interesting. There was another statute that was compared to where perhaps consumers could make a complaint to the Attorney General, and the Attorney General's office would decide whether it's founded or unfounded. And if they find that it's a founded complaint, then the consumer could enforce it. I thought that was a really interesting idea, and what that plays off of is the consumer concern, because what consumer advocates are worried about is that the AG's office will not have the resources to adequately enforce this, whenever there's a violation. And that kind of middle ground might have allowed consumers to bring suits, but have the AG's office be a gateway. Anyway, I'll stop there, but I do have a lot of thoughts about it, and I know that it is one of the key issues about these statutes all over the country.
Yeah, no, I completely agree. And I'm really excited, or I guess I should be really interested to see how the enforcement of privacy laws play out, especially here in Virginia, because I think that's really going to help shape the laws to come as well, including possibly a federal law. All right. Okay, so let's change gears a bit and get into your privacy predictions. So Kyle, this next one is for you. How do you think technology advancements will impact the future of privacy? So for example, things like facial recognition or biometric data being used for things in your world, like verification or fraud prevention.
Yeah, so how much time do we have for that one, Janine? There's a lot there. So I think when we think about technology advancements, people can think about all kinds of use cases, and you've mentioned a couple: facial recognition, biometrics. There's other things that we don't even know about yet, right? So you really have to think where could everything go as it relates to privacy, and let's talk about consumer use. So I think there's probably a couple different elements to this. There's an element in regards to how states may act as a result of technology advancements. And then I think there's an element around consumers. And on the state level, it's really interesting because we've seen a couple different approaches. We've seen these really specific targeted type of regulation happening. I think one of the most well-known and older ones, 2008, Illinois has got the biometric, I'm going to mess it up, I'm just going to call it the BIPA Caroline can correct me on that one, but it's all around regulation of biometrics. And that's one that I think every year there's new privacy laws on the books in Illinois to either amend or repeal it. So that kind of opens a question around like, well, what's so wrong about it? And I'm not the legal expert to tell you that. But you've also got facial recognition legislation. I mean, we've got Virginia House Bill 2031 that talks about facial recognition with policing. And then you've got this really interesting, again, very specific law around that's been proposed. It's called the Algorithmic Accountability Act. And that's all around using AI decisioning. So that's kind of one approach. It's this very specific, let's look at specific technology advancements. Let's try to regulate, let's put some privacy law around it. That's probably, it may work in certain cases. I think in others, it may not. I think there's probably a challenge with regulation being able to keep up with technology. I don't know if that's really worked that well historically. So you have this other approach. You have the approach that some like California are taking where, hey, let's get these super broad definitions of personal information. I think when folks got these personal information definitions, a few of us that were kind of looking at the operational side were like, wow, that's super broad. And so you have that approach where we can define personal information in such a broad way that it includes what we know today. It also includes maybe things we don't know about that could be coming in the future and regulates that to a degree. And California, they were a little bit also forward looking in terms of looking at personal information. I mean, one of the pieces of personal information is olfactory. Now, olfactory is data about your sense of smell. So many of us probably aren't thinking about use cases for that. There are some that exist that I understand, but it's kind of forward looking like, well, that is a piece of data that may matter one day. So let's go ahead and include that in this broad definition. So the other element of this is the consumer side. I think the best way for consumers to interact with technology in a way that shows their concern for privacy is in how they use privacy settings, how they engage with companies, and where they spend their dollars. And I don't think we're there yet. I think that with one thing that privacy legislation does, it helps with the clarity in privacy statements. Because once you get to, I don't know, scrolling down a little bit, your scrolling gets faster, it gets even faster. And then you're like, all right, where's the button to just say I'm good to go because I want to get access to this product or service. And if you think about Alexa, a few years ago, people were probably kind of creeped out by the fact that Alexa was listening, and then you'd get ads on a different device, and a lot of fun kind of quirky conversations about the type of ad that got served based on the conversation that Alexa may have heard. But consumers get a little bit desensitized to that. I think there's a lot of Alexas sitting on counters spouting off the weather every day, or in my case, playing DJ to my two girls. So, in summary, when it comes to how technology advancements will impact the future of privacy, you've got these specific laws at the state and federal level. You've got these broad definitions, and then you've got really the consumer element of it. With this question, one thing that I listened to over the weekend, it'll tell you a little bit about myself, but there's a podcast called GeekWire. I could just stop there, but I'll keep going. So there's a podcast called GeekWire, and they had Susan Delbaney on there. And Susan Delbaney was the one that introduced the federal privacy legislation. So I would just encourage folks to listen to that. She's got a great perspective on how far we've come and how far we still need to go. But that would be kind of a follow-up for folks if you want to learn a little bit more about the federal side and specifically her perspective. So Sargini, that was, like I said, how much time do we have, right? There's a lot there in that question.
No, I find it really interesting. And I think you brought up a good thing. So I'm going to kind of go off questions for 2 seconds and just say, thanks for sharing that source, Kyle. And if any of the other speakers have anything that they like reading or getting their news from, feel free to throw it in the chat after the meeting. I think it'd be interesting to folks to just kind of know where your source of information is. Okay, so I think the next question does build really nicely on some of the ideas you just went over, Kyle. And this one's going to be for all the panelists. But what do you think the future of privacy landscape, what do you think the future of the privacy landscape looks like? Do customers become more and more privacy centric and that therefore legislation to match that demand? Or does technology and convenience win out? Do people want immediate access to the weather in the morning when they wake up? So John, let's start with you and then we can go to Caroline and Kyle.
That's great. And I love the question. I think, ideally the answer to that question is it's an and, it's not an or. You can have privacy and you can have convenience. And I really think, to Kyle's point, the technology will play a huge role in that. I think of, technology that might let us in the future grant or revoke access to your data, to your personal data on demand, like a Snapchat or vanish mode for data, whether it's at a point of sale or at your doctor or boarding a flight. It seems like something like that could protect consumers from unethical business practices or the lagging laws or enforcement that are supposed to be there kind of on your behalf as a consumer. You could lose some convenience or that service having deeper understanding of your preferences for the next time. And it could create some challenges around transaction auditing or ledger activity. But I think that if you can find the sweet spot there, that granting and revoking on demand, would certainly then I think mean that the risk of you having your data involved in a rights violation or a breach would be pretty close to zero. So I'm actually hopeful that we will have that both kind of that interest in kind of requirement for privacy met with convenience through technology.
Yeah, I mean, John, I agree with you entirely. And I think circling back around to something you were talking about at the beginning of this panel, federal privacy legislation, I think could get us there a lot faster, because where I see us going in the short term is just a smattering of different state legislation, much of which is similar to one another enough to make it really complicated. It's kind of like when there's just a few differences in the words, your lawyers will go to town on those differences and make it complicated. And so what do I see happening? I see maybe a lowest common denominator approach. And by lowest common denominator, I mean, I say that in a way that's good for the consumer. The most consumer friendly approach is what I think most companies will take if they're operating across state lines, because it will be too hard for their departments internally to parse when they receive a request from a consumer to exercise one or multiple rights under a state law. Where is that consumer? Where was the consumer when they got when the information was collected? Are they living in multiple places? It could just be way too complicated. So you would go to the easiest solution would be the blunt solution. Take the most consumer friendly approach and apply it across all the states where you have obligations, or potentially just in general to all of your customers. Now, that said, there is in sort of the legal realm, there is this idea that a Supreme Court justice came up with a long time ago, that the states are the laboratories of basically American law. And what happens in states, while it is annoying, when you're operating in an interstate environment, is that they are testing different legal paradigms to see what works, what doesn't. They'll amend it. We've seen that used liberally in California. They will amend, and then they'll have regulations. And the federal government has the advantage there, as well as the states that wait, of taking a look at what is good, what is not so good, what is expensive and doesn't have a big value benefit for consumers. And then they can take those lessons. And then I hope that what John has, I think predicted will ultimately happen, or at least is very hopeful will happen. I agree that the federal government will take those lessons learned from the states as laboratories and make a federal privacy legislation that could lead to a situation where we do have that kind of real-time data sharing, data deletion. All of those things could be done more in real time because it's the same everywhere.
Just to add on a little bit there, because I agree with everything both of you guys said, and I think the only thing I would add is for folks that are newer to the privacy space, and there's a lot of people that you kind of have to change the definition of new, because I think a lot of folks are new to the privacy space with California going into effect, and that kind of pulled a lot of people into this entire industry. But if you're newer to this conversation, what I'll say is there's a lot of activity right now at the state level, and you can look at some different maps of what's going on. It changes every week. And you know, January of every year, we all sit back and say, what all is going to happen in this space this year? And the prediction question is going to come up. It's going to continue to come up in most panels that you'll listen to until there's federal legislation. But the question has been raised in 2019 when there was a ton of activity. It was raised in 2020 when there was a ton of activity. And so it's being raised again. And so I say that because here we are, we've got 2 comprehensive state laws. Virginia is very new, but there's 2 comprehensive state laws, and we've had years of a lot of conversation. So I do think 2021 is different. I think, you know, yeah, we all want federal, we want something that's consistent, that can be consistently applied, but we probably will, you know, end up seeing a few more in there. But I wouldn't get too hung up with the 15 states. There's 20 states with private, because we'll kind of go through that cycle a little bit. Washington is always Washington state is like, it's going to happen this year. It's going to happen this year. And I think they may have missed it again this year. So it'll just be very dynamic space for us.
One other observation I had that, you know, when Kyle was speaking earlier about biometric data and just this, when we think about the future in general of privacy, you know, data privacy, and think about how hard it is to imagine different data points. When he was talking about olfactory data, I was like, oh my God, I mean, and it's not something that I've really thought about, and that I'm sure there are use cases. But one thing in the Virginia law that will be really interesting to see play out is that states seem to recognize that this biometric data is special, right? They actually, in the Virginia law, it's sensitive data, and there's different procedures, extra procedures set up to protect that, including affirmative consent that consumers have to give to have that information processed, and that includes having it collected. But how will we get affirmative consent from Virginia consumers to certain types of data that may be very hard to describe? How can you know that you've sufficiently described what you're collecting such that the consent you've received is meaningful? And so that is another thing I think will get increasingly complicated in the future of privacy law, that federal legislation will be helpful because it could be a centralized space to make these calls. But I don't think that the actual issues are going to get any easier. They are going to they're going to expand, and who knows, maybe 5 years from now I'll be using olfactory data all the time, and maybe it's the secret sauce we've been missing out on. So.
And I would maybe just add that is that's one of the benefits with California leading, is they were very, very broad in their definition of PI, as mentioned multiple times. I would suggest, even for our friends looking at Virginia as kind of their first foray into the law, become familiar with how California defines it. Virginia may define it even more broadly. Other states could, but it would be tough. Like, it was really broadly defined. And if your solution, you're just starting for Virginia, if you could work backwards from the California definition, I don't think you're going to be far off. Again, I wouldn't say ignore specifics for Virginia, but that's a great starting place. It will certainly then challenge kind of your ability to maybe think through use cases where each of those exists. But if your solution is working backwards from the broadest definition, I think you'll be pretty well prepared for state-specific nuances.
Yeah, John, that's really great advice. Well, I appreciate you guys answering all of my questions. I think we have a few minutes to take some questions from the audience. So let me see if I can figure out chat now.
I could probably serve those up for you, Janine. Callie Rogers asked, how are you planning for dealing with conflicting rules that come out across the states as things move forward?
I'm happy to take the first crack at that. I think I spoke to this just a moment ago, but I'll reiterate that I think doing the most consumer friendly thing, if it's too hard operationally to make distinctions between states, your business may not be large enough to support an expert on the California privacy responses and the Virginia privacy responses. And so I think you'll see that many companies will be taking the approach of, all right, we'll compare the two. If there are differences, we'll take the more consumer-friendly, protectionist approach.
Yeah, Carolina, I would agree. One of the things that we used as a bit of a guiding principle is honoring this request of the consumer in kind of our desire to kind of meet them where they want to be met is no different than maybe how each of us think about serving those same clients or same consumers for a business transaction that you would prefer that they were kind of reaching out to you for. So if you're able to take kind of your approach from how you would treat customer service or treat sales or just general kind of engagement with your customers, if you kind of put this law or these laws kind of in that same vein of like, well, it's just another consumer transaction from which we need to just do a great job and help that experience. I think that it at least turns your mentality around to your point, Caroline, being consumer friendly. And I think that it helped us think through California, like it's just the right thing to do. And we would do this for helping someone with a sales question about a new car, about a car they were considering. Let's go above and beyond as it relates to trying to do the right thing for the consumer when they want to know more about how we use their data.
Yeah, the only thing I would add is, I think what we're saying in summary is there's these two approaches. Either a broader is better, meaning we're going to try to really find that lowest common denominator, and then also the really state specific. And I think there's going to be kind of this middle ground in between. I love putting the consumer hat on because these are consumer laws. That's who they're for. Alistair McTaggart didn't do this because with CCPA because he was mad at the tech companies. He did it because he was doing it on behalf of the consumer. And so having that consumer hat on is a great way to think about it. I think when we look at Virginia, we look at California, there's going to be places where we're like, awesome, we're already doing that. That works great. There's going to be a place where we say, it's a little bit different. What's kind of that least common denominator? And then I think, unfortunately, there are going to be some nuances where there has to be kind of a state-specific approach to certain things. So it's kind of, I think time will tell a little bit as we get more clarity with Virginia and then others that may be coming.
I completely agree, Kyle. One of those areas where I think Virginia will just inherently be different, and it'll be this way with any state that has just a completely different offering in their law, is the appeal process in Virginia. So when the consumer exercises their right and the company, looks at the exceptions or whatever and says, okay, we actually don't have to delete because it falls within this exception under the law, the consumer has the right under Virginia's law to appeal that. And that's kind of new, and there's no way around it. There will have to be a Virginia specific appeal process. And it may be that some companies incorporate that appeal process across the board, but they don't have to. And it may well be that becomes a Virginia specific compliance imperative.
Yeah. The other one I was thinking about, Caroline, too, is the correction. I think it's like the right of correction for Virginia.
Right to fix, yeah.
DPR or not. I mean, that between California and Virginia, that's like, that's a little bit different. That's the other one that came to mind for me.
Yeah, that's a great point.
Okay, we just got another one I think is really interesting. Are there any potential loopholes for bad actors may try to exploit? So for example, if a person who does not intend to pay their debt asks that their personal data be expunged, I know a lot of, some of that data is excluded from, at least Ccpa in Virginia, but in general, I guess, do you think that there'll be any loopholes for bad actors out there?
So It's a great question, and you're right, Janine, that for many financial institutions, though not all, but many financial institutions are just exempt, period, from the Virginia statute because they have to comply with a federal law called GLBA. In California, there's not a total exemption. It's really complicated, and I won't get into it, but they still have to pay attention to California for certain types of data. But yes, are there loopholes they may try to exploit? I think, in my view, the exceptions from that are available to companies that are complying with these laws are pretty good, actually, because they give you the ability to say, no, we're not going to delete your personal data if it relates to an account that you requested with us and that is still active, and that would fall within an exception. So I find, in my view, the exceptions are pretty good, but I would be curious to hear what my fellow panelists have to say about this, because it's a really good question.
Yeah, I'll say exactly right, Caroline, that the exception clauses are important. We are fortunate that we have great counsel as well. It is absolutely important, though, to help educate your consumers. That it is absolutely something that, while you want to honor the right, there are federal laws and there are real reasons to retain data and manage data. It's on behalf of the consumer, whether they actually recognize it or not. We talked earlier around, like, if we truly deleted everything and the consumer came back 6 months later and had a complaint that we couldn't service them or that we couldn't help them in the way that they wanted to be helped, and we said, well, we did what you said, we deleted all your data, right? So there's a little bit of, not always do folks kind of maybe understand the unintended consequence of just kind of a scorched earth approach to deletion. And so I think that all companies should be conservative and should be in line with the law. But at the end of the day, we needed to educate our consumers around where we thought that was where we needed to continue to look to other reasons where we may still keep some data. I would also say that I think that for a lot of consumers, what also is important about the law, maybe back to the loophole or bad actors side of it, is having a good identity process on the front end to really know that you are validating that it is the person that should have permission to have this data disclosed or deleted. Is really important as well, and it's language certainly included in the laws, but that also is something from a solution perspective to take some thought about what is good identification and verification that the consumer is who they say they are. That if that's not well tended to, then I think you could open yourself up to bad actors kind of exploiting the data disclosure port.
Yeah, nothing to add from me. Just want to say, John, thanks for the shout out for identity verification. Appreciate it.
All right. Well, just looking at the time, I know we are at time. We did have a couple other questions in the chat. So if you can stay on and hang out for a few more minutes, we can get to some of those. But I did want to just pass it over to Nick to share anything he needed to for some of the folks that do need to drop off.
Thanks so much, Janine. And yeah, I just I wanted to say a quick few words to everyone who does need to drop off. We have a lot of things going on at rvatech, not just the Data Summit, but beyond, that I wanted to make everyone aware of. So if you liked what you heard here today and you haven't attended events before, please go to our website, rvatech.com. We have events throughout the spring, summer, and fall. And fingers crossed, we're hoping to get back in person in the early part of the fall. So please check those out. Things coming up include a webinar on April 28th about making code easy to modify. The kickoff for our Drive conference presented by Women in Technology is May 13th. So that's just around the corner. And we also have a career fair coming up on May 26th. So if you're looking for a new job or your company is hiring, please consider registering for that event. Again, May 26th is a career fair. And as Lori mentioned, there's going to be a lot more data science content coming throughout the summer. Our other two conferences, Edge, which is about cloud, DevOps, and enterprise architecture, as well as Drive from the Women in Technology group, are also putting on content throughout the summer. So please keep an eye out for that. And last but not least, I really wanted to highlight our RVA Tech Talks podcast. It's available on all podcast platforms. And it's in its second year now, and it's really gaining some steam, and love for you to check it out on our website at rvatech.com. With that, I'll pass it back to you, Janine. Thanks so much.
Great, thanks, Nick. Okay, so getting back to some of the questions, let's see here. So we talked a little bit about the consumer kind of driving the conversation, right? Like what is best for the consumer. So this one talks a little bit to that. And I've noticed this even when checking out some other privacy policies and what other companies are doing, but there seems to be very different formats that consumers are getting back in terms of their data. So whether it be just a data dump of, an Excel spreadsheet, I've seen even machine readable data come out. I have seen very pretty, more PDF versions that anybody could, consume very easily. Let's see, I want to make sure I get to the heart of the question. If and when there is federal privacy legislation, what does the ideal compromise between the pure data dump and the data look easy to understand look like to you guys?
Well, I'll just start with saying that I think, again, very similar to other responses around being consumer centric. I think that certainly there's the provisions around technical limitations and challenges the companies may have to produce something that is more consumer friendly. But I would say that if we do a great job kind of answering the call towards the request for the data or the request for completing the request, I think at the end of the day, you're just helping your company be in a great position to say that you've really met that bar and you've done all you can to be on behalf of the consumer. And so I don't know that federal law may dictate format, but it may, and I wouldn't be surprised if it does, that it is again kind of leaning towards what is best for the consumer. So I think we opted to go more consumer friendly just because, again, we thought it was the right thing to do. And we thought that was consistent with how we try to manage other kind of customer service like responses and requests. So I think that that's probably a safer bet, but I'd certainly love to hear what others think.
I think it's a great place for every lawyer's favorite word, which is reasonable, right? I mean, you can't give effect to the purpose of these statutes if the consumer is unable to make any sense of what's being produced to them. So it's going to have to be produced to them in a reasonable form, and whether that's spelled out explicitly in the statute or litigated afterwards, or there's regulation, we'll see. But certainly producing something in just a machine readable dump is not going to be something that I think is going to be very helpful.
Great, thank you guys. Anybody else have anything to add to that one? All right, moving on to the next one. Any thoughts on if we would ever federally create a digital bill of rights?
Yeah, that's a great question. And I know that there have been rumblings of that concept, not even just at the federal level, but like companies coming together and talking about creating these to sort of self-identify within their industry principles that they'll all agree to abide by. I think probably the stronger protection, maybe ironically for consumers, is to actually have, rather than the digital bill of rights, to have a law that sets forth the actual requirements, because the bill of rights could be broad enough at the top that it might not give enough guidance to really give consumers what they want, which is protection of their data and control over the data about them, and to give companies what they need to be able to comply with the laws, which is certainty. So I think that maybe the way to do this is to have this sort of, in some laws, what will happen is there's a section at the beginning where they say what the purpose of the law is. And it's on its own, standalone, and it's kind of nice because it gives you the context for the very specific lengthy provisions that come after. It can be helpful for courts later if you do end up in, God forbid, in a situation where there's a lawsuit. The consumer and the company can both look at that first section. If there's any question about what the law, the specific provisions of the requirements, if there's any question about what they mean, they can look at that purpose section and be like, look, it's clear that Congress intended to give consumers the right to this. And we will read the very specific provisions in the law in accordance with that understanding. So I think maybe I would recommend, if we did something like this, to encourage it to be in the sort of the first section of the federal law.
Caroline, for those that are familiar with GDPR, do you think that that's a good example of what you're talking about?
Yes, and I think, and that's sort of a unique, it came out of a lot of work to get there, right? But yes, I think that that's right. I think that where this might start, though, is in private industry, and then take those concepts, and the digital bill of rights is even broader than privacy, though. So that may be a harder part about that, is I think that some people, when they talk about it, are also extending that to right to access to, internet, right, the ability to actually be able to have a digital presence. So that will be, it's a little broader, and I think that it might have to get divided up piecemeal if we did it in the way that I was just talking about.
Great, thanks, Caroline. Okay, well, I think we've covered all the questions in the chat, and we're about 7 minutes over, so it's probably a good place to end. So I just wanted to say thank you for a great conversation, everybody. Thanks to all that posted some questions for the audience. We really appreciate your participation. And yeah, it was great chatting with you all today.